All right. We have a trial calendar to call. There's not much left on it, but there are a few. I'm going to jump straight to those. We did have Mr. Hinton brought back over, but I don't see Ms. Young, so I'm assuming nothing changed on that. You didn't hear anything, Ms. Hall, about anything changing with Mr. Hinton? I know it's not your case, but hopefully Ms. Conberry or Mr. Abate would have alerted you, like, yes, it's a plea.
Yes, I haven't heard anything.
Okay, so we don't need to bring Mr. Hinton out. Still turning pages here. Mr. Williams took a plea. So we've got Mario Duncan, and Mr. Duncan should be in custody, and there's his attorney, Mr. Johnson. Is that still expected to be a plea? Okay. I don't see Ms. Patel on the call yet. Can someone track Ms. or yes, Ms. Hall? Yeah.
I let Ms. Nelson know Ms. Patel will be about another 12 minutes.
Okay, great. We're just making a plan. You should get comfortable wherever you want to be, Mr. Johnson. And we know that Mr. Duncan will be a plea. Nikki Young, I believe I signed a no pros. Is that correct? Okay. Antonio Carter. That is Ms. Wood and Ms. Beza. Good morning. And Mr. Carter.
Morning, Judge.
Morning.
So, Ms. Wood, what's happening in your client's case?
Judge, the state has offered virtual PTI in this case.
All right.
I do have a proposed order ready to submit to the court.
What are the basics of that?
Judge, he is involved in, he's volunteering through his group, the American Legion that he's a part of. So he's going to continue volunteering with that. He's going to maintain gainful employment. He just got a new job with O'Reilly's Auto Parts.
Fantastic.
And he also served about 24 days in custody for this case. And I believe, I'm not sure if the state wants to elaborate on the complaining witnesses' desires for this case, but that's the requirements that Mr. Carter's going to maintain.
That he maintain employment, that he do volunteer work. It happens to be through American Legion.
Yes.
What about contact with the victim? Is some family member or a connection to Mr. Carter based on the nature of the charges?
Yes, Judge.
Yes, sir. There's been no contact with the surviving victim, Lacey Blake. The second victim, Alfredia Coleman, has passed unrelated.
Okay, I was going to say, boy, virtual PTI is an impressive offer.
No,
It's a
no.
dead victim. Okay,
Ms. Coleman is the mother of Ms. Blake.
got it. Okay,
And Judge, I do want to point out, there are children involved. So I think right now they go through a third party. So if that could still be kind of the idea that.
I won't change anything in the bond. If the conditions of bond allow Mr. Carter to see his kids, I'm not changing that. The only thing that would change the conditions of bond would be something in the virtual PTI order. And if that needs to be in there, we can put it in there. But it sounds like maintaining the status quo, because Mr. Carter, you're going to remain on bond. Whatever the terms of your bond are, remain in effect until you complete the PTI. If you do that successfully, the state moves to dismiss. I dismiss your case, then no more bond. And you are able to interact with people in a different way as long as it is lawful. Does that make sense?
Yes, sir.
Do you need to talk to Mr. Carter to see if we need to tweak anything, or do you think we're okay?
Judge, we did go over this pretty thoroughly. This case is it's a 2017 incident date. And I would just like to let the court know he has not had any incidents with the law since 2017. So I think he's going to be okay with maintaining his current bond status.
Great. All right, then we'll leave it that way. How much time does Mr. Carter get to complete the terms of PTI? Because we'll need to let Ms. Nelson know when Mr. Carter should be on a calendar again. And you will need to show up. If you've taken care of everything and it's been documented, you got that to Ms. Wood, and Ms. Wood gets it to Ms. Beza. Ms. Beza can just send notice to us, case dismissed. But we do want to get a calendar date to hold everyone accountable.
Judge, I believe within 6 months, we'll be able to have everything buttoned up and submitted to the state.
Okay, great. So Ms. Nelson, I guess we're looking at 8 + 6 is 14. February, I guess it would be late February, early March, we want to get Mr. Carter's case back on a calendar.
Okay, Judge.
Thank you. Ms. Wood, anything else on behalf of Mr. Carter?
No, Your Honor. Should I submit the order to Ms. Nelson or directly to the?
So if it's electronic, if you would email it in Word format to Ms. Nelson, then she'll get it to me in case I need to edit it at all. I'm not going to add terms or conditions because you all have negotiated that. I will put in, he's got 6 months to complete it if that's not in there,
Yes, Judge.
just so that that clock is running. And then as soon as this order, put it on the dead docket, or do we need it?
If it's on the dead
Good,
docket,
okay, excellent. Okay, then that'll take care of everything. Mr. Carter, do you have any questions?
No, sir.
Okay, if you do, Ms. Wood's the right place to start. All right, thank you both.
Judge, may I be excused?
No, I need you to stick around for the next position I'm gonna call. Mr. O'Neill, we've got, that's one of the people who should have been, I'm remembering now who the third guy was. That's Mr. O'Neill. Mr. Gaffney's on the call, and thank you, Mr. Gaffney, for being here. Mr. Gaffney has withdrawn from Mr. O'Neill's case, and there's a question about getting Mr. O'Neill appointed counsel. It won't be you, because I believe Sharma Patel represented the co-defendant, and so it may be Mr. Webb, it may be someone else, but we're going to bring Mr. O'Neill out just to let him know what's going on. He can tell us if he is a person of means, if it's been his family that was hiring people, but he's had 2 different retained counsel, at least 2. And his case is old, and even though it suggests he's only been in jail for 75 days, that's only because he went away for a while on a revocation. He's been in jail for a long time. Co-defendant has pled. So someone needs to help get Mr. O'Neill to the finish line, whether that's a plea or a trial. If we could bring Mr. O'Neill out, that would be great. Sarge, thank you. Mr. Webb, were you on the call for any other reason? Do you have an update on any of your cases?
No, Your Honor, but being new, I guess I was confused and I thought I'd better be here instead of not be here, so.
No, I think that's smart. I'm glad you are. You may have had an update, but I know we continued, I think, all the cases. Oh, no, you may be here for a reason, so sit tight because we have a second calendar that has a Dante Buford on it. Hopefully he's showing up because it's a notice calendar, and he was going to enter a plea that had been negotiated by your predecessor, not meaning Ms. Snyder, but your supervisor and Ms. Hall. So we'll talk about Mr. Buford in a minute.
Okay, Your Honor. I'll sit
all
tight.
right.
You want to come to your courtroom? I'm here in the courthouse.
Well, it's not necessary if Mr. Buford's not showing up, so we'll figure that out.
All right, I'll just sit here. Thank you.
Okay, great. All right, let's go on the record in position 13, that's State versus Anthony O'Neill. Good morning, Mr. O'Neill.
Good morning, sir.
Mr. O'Neill, I brought you out here to get an update from you on representation. Mr. Gaffney, who was representing you for a while, has withdrawn. I've allowed that to happen. He's explained to me what is going on. And I need to know from you whether you're in a position or your family is in a position to retain counsel, or if you need an attorney appointed to you. I ask because you've had retained counsel before, Mr. Wright, Mr. Gaffney, and so the public defender, who I don't think can represent you because I think they represented your co-defendant, but they said, looks like this guy's got money. I don't know that he qualifies for appointed counsel, but money can run out. And you are certainly going to have a lawyer one way or the other, unless you're here to tell me you're going to represent yourself, which is a whole different story. And we have a different conversation about that. So tell me what you're thinking is happening.
Right now, my family working on hiring a counselor, but I don't know how long it'll take.
Okay. Do you have a feel if it's weeks or months?
Probably like a month or 2.
Are they planning on bringing Mr. Gaffney back, or are they planning on bringing in another lawyer?
Another attorney.
Okay. Well, I guess what I can do is reset this for a little while. and then maybe you can have an update from your family, or maybe someone from your family could come to court. It's a tricky balance. You are entitled to any lawyer you can afford. If you were a billionaire, you could hire any lawyer you want. If you are closer to the end of the spectrum where you would need a lawyer appointed, we don't wait forever. Your case is old, it's getting older. And just like you're entitled to a speedy trial, meaning a prompt trial, the state, the public, and their victims in this case, they're entitled to getting closure on this as well. Case isn't getting any younger. So what I'll do is get you back here, we'll say in about a month, to get an update from you or a family member as to how likely is it that they'll be in a position to hire someone, or if instead we ought to appoint someone. There are plenty of real good lawyers out there who can be appointed to represent you, and they'll be just as dedicated to working on your case as Mr. Wright was or Mr. Gaffney was. I don't know why things ended with Mr. Wright. I've got a rough idea why things ended with Mr. Gaffney. And if there's going to be an issue in the future where your family is able to pay a lawyer for a little bit, but not all of it, we have to just stop and acknowledge that maybe the money's not there. And we need to get you a lawyer who will be focused on your case and will be able to see it all the way through to either a trial or a plea. Whatever's going to happen with your case, it's going to be one of those two things, I suspect. And when you do that, your case, and you know, you better than I do. You've been in jail for a couple of years now, and it's time to figure out how we're going to resolve this. So I'll work with my staff, and we'll get you back here probably in early October. So we give you, today is the second to last day of August. So we'll give your family the month of September to see what they can do about lining someone up. Mm-hmm. And obviously, if that person is hired, he or she can file what's called an entry of appearance. And that lets us know, hey, Mr. O'Neill has a new lawyer, John Smith, Jane Doe, whoever it is. And then we can get moving again. But if that has not happened and it's been about a month, we'll bring you back and we'll just talk again about what's happening. And hopefully your family can keep you posted. How often do you speak with them?
Every day.
Okay, well, good. Then they're going to be in a position to let you know, hey, we cannot do it. The lawyers want too much. It's a serious case. Or we've got someone, but we won't have the money until I'm making the date up, October 15th. But it'll need to be that certain when we talk again is we found someone and we're going to have the money by this date, or I'm going to have someone appointed to represent you. Last thing I'll say, and I'll see if you have any questions. You should know, if in October I appoint a lawyer to represent you, that is your lawyer unless your family ultimately hires someone. So you're not prevented from bringing someone in. Let's say your family says, you know what, it's not going to be until January that we can afford a lawyer. If your case hasn't been called to trial before then, you can always bring someone in. You're not required to keep the appointed lawyer because one was appointed. You may want to. You may be real impressed with that lawyer. But if it just takes longer than you were hoping for your family to get an attorney, that person can always pop on in and replace the person that you have at that time. Does that make sense?
Yes, sir.
All right. Any questions about anything?
Yes, sir. Like, how would I go about the situation with Mr. Gaffney? The reason he retained from my case is he was asking for extra money because he was making promises like saying he'll get me a bond and this and that, and we gave him extra money. He never got the bond, so he withdrew from the case when we asked for the money back.
So you, your family, and Mr. Gaffney would need to have that conversation. If you had any concern, or your family had a concern that Mr. Gaffney didn't do something that he represented to you that he would, your family can always talk to the state bar. All lawyers are part of the Georgia bar. And sort of like if you went to McDonald's and you were unhappy with the service, you could talk to a manager to say, look, this guy was a bum. He was rude to me, whatever the deal was. People can talk to the state bar to say, I've got a concern. I may have a misunderstanding with my lawyer, but I thought A and B and C were going to happen and they didn't. And the folks at the bar can say, well, we'll talk with Mr. Gaffney. They may say, what he explained to you is how it works. There's nothing wrong here. And I know I don't get in the middle of that. That's a matter for a former client, because you're now a former client of Mr. Gaffney and Mr. Gaffney, and then ultimately the state bar, if that's what you and your family want to do.
All right.
Okay.
Yes, sir.
All right. So, Mr. O'Neill, we will see you again in early October, and we'll see what kind of progress you and your family have made in retaining someone else. And if not, we'll make sure we get you a good lawyer.
All right.
All right. Thank you so much.
All right. You're welcome. Thank you.
May I be excused, Judge?
Yes, sir. Thank you for joining us.
You're welcome, sir. Thank you.
May I be excused as well?
Yes, and Ms. Wood, now you can go.
Thank you, Judge.
Thanks.
Have a good day.
You too. So, Mr. Johnson, when Ms. Patel joins us, we will switch to your client. Mr. Tavares, if you would come to council table over there, I'm gonna just start talking with you. And are you Mr. Whitenauer?
Yes, good morning, Judge. John Whitehour, on behalf of the state, it's WGIT and tomorrow.
I've seen it on the pleadings. So Mr. Tavares's case then is the last remaining case, assuming Mr. Duncan enters a plea, and we will sort that out once Siri Patel gets here. So my expectation is that we will pick a jury tomorrow morning. We'll meet here first. So I need Mr. Tavares, Mr. Whitenauer, and Mr. Parrish, insofar as you're assisting Mr. Whitenauer, to be here at 9 tomorrow. We will talk logistics about jury selection. Jury selection occurs in a different courtroom. We'll all go down there together. It's going to be 1D, but that is a larger space, so we can fit 60 potential jurors there in a socially distanced fashion. We'll do the trial here because we can fit 14 jurors out there in the gallery. But it's a slightly different setup than Mr. Tavares you may have had when this was tried. Was it tried in front of Judge Downs or Judge Reeder?
I think it was Reeder.
Okay,
2 years.
regardless, you would have been in a courtroom like this. The jury would have been in the jury box. Can't do that right now. So the jurors will be out there, and you can see how the tables are set up. This is the courtroom where it'll happen. So you're actually facing each other. You've got the jury to, if you're Mr. Tavares, to your right. I'll be up here, but of course you guys are focused on the jury. We'll talk tomorrow morning about the process of jury selection. I will have for you all the questions that I'll be asking the jury. I base that off of questions I have to ask jurors because of case law and statute, as well as submissions from the two sides. Mr. Tavares, I didn't get any proposed questions from you. They were due on Friday. I did get some from Mr. Whitenauer, so I've included some of those. You all will be able to look at the whole list. There won't be any surprise questions. So I'll give you tomorrow morning the set of questions that I intend to ask, and you'll have a chance to say, I don't think you should ask this one. Well, I think you should add this one that I previously requested, so it would be coming from the state, and I'll explain either why I excluded it, or maybe you'll convince me to put it back in there. But we'll make a record of all of that. There is a 413 motion that the state filed concerning another alleged incident involving a customer. I didn't know that was there until I was looking at the docket this morning. I wanted to confirm that I had entered a very clear order that honored Mr. Tavares's right to represent himself. And we had that hearing, and there is an order in the docket indicating that Mr. Tavares made a knowing and intelligent waiver of his right to counsel and a knowing and intelligent enforcement of his right to represent himself. So we're good there. But it was in looking at the docket that I saw the 413 motion. And I'd like us to talk about that a little bit this morning. just so that both sides have a little bit of information in advance of trial. So I don't know if you're familiar with its contents, Mr. Whitenauer. I don't mean to put you on the spot. If you want to talk about it tomorrow morning, we can. We will go downstairs as soon as we are told that the jurors are ready. So I don't want to pack more in tomorrow morning than we have time for, but we probably have 45 minutes tomorrow morning to talk about things. Mr. Tavares, a 413 motion, I'm going to explain things to you that you already know, and you can just say, Judge, I understand that. I am not ever talking down to you, other than physically, because I'm sitting up here, talk down to everyone. But it's important to me to make sure that you are understanding as best you're able to things we're talking about. And lawyers don't use code, but they sometimes refer to things by a case name, like a Ferretta hearing. It's called Ferretta because there was a case. 413 is a piece of the evidentiary code. I'm guessing you read the motion. It was filed a long, long time ago, where the state wants to get in at your trial evidence about, I think it's a Ms. Gibbs, who was a client of yours 6-7 months before the alleged incident. That's our trial.
I'm sorry, Judge.
That's okay.
She testified at the last hearing.
Okay, so you're familiar with that whole situation.
I went through a whole 3-day trial 2 years ago.
No,
So I know about Ms. Gibbs.
Okay, so Judge Reeder allowed in the 413. I just didn't see an order, but maybe there was a hearing before trial. I don't want to leave something unresolved before trial. That's all. So let me hear from the state first, because it's their motion.
Okay.
But I will, another promise I have for you. I'll always hear from both sides, so don't assume because I start with the state, that's all I'm going to hear from.
Okay.
Both sides will get a chance to offer their perspective. Mr. Whitenauer.
Yes, Judge, thank you. Yes, the state would intend to introduce the evidence of Tamika Gibbs from an incident that occurred in October of 2014, in which Ms. Gibbs reported that a defendant had touched and pinched the victim's, Ms. Gibbs' nipples during a massage. And we would intend to introduce that under 413. She has been subpoenaed.
So, did Judge Reeder, I understand she let it in. Is it your opinion that she had a sufficient hearing and made a sufficient record before she let it in?
Cannot make a representation to Your Honor about that. I was not with the office at that time. I can look back at the docket to see, but it sounds like Your Honor's already reviewed that and did not find any documentation. I don't know if the sheriff has any recollection or knowledge.
Don't worry, I'll call you. You don't need to raise your hand. I promise I'll turn to you.
Judge, I did the same search you did looking for that specific order. That was one of the very first things I did when I got the case. I didn't see that order. I know that it is common practice to have that hearing orally without an order being issued immediately to trial. I shouldn't say common practice, but it is practice. I've seen it happen before. My assumption was that was the case, but I don't, again, that's only my assumption. I don't want to make representations for that is in fact what happened, because I don't have verification.
Who prosecuted the case for your office?
It was Dallas Cox. I can reach out.
Oh, that's right, because his name was on the 413 motion.
I can
Okay.
reach out to Mr. Cox and get verification on that.
Okay. A third prosecutor has some information.
Sorry, I'm not actually, I'm texting Mr. Fox right now. I can let you know.
Okay.
Actually, he's messaging back.
Well, Mr. Tavares was there, so now your turn, sir. My question is simply, was there a hearing, a discussion with Judge Reeder before your first trial about the Ms. Gibbs situation, where both sides were, you had a lawyer back then, so your lawyer and the prosecutor would have had a chance to say, Judge, here's why it should come in. That's what the state would say. Your lawyer would say, Judge, here's why it should not come in. Do you recall something like that happening?
Yes, I recall the whole thing.
Okay.
My lawyer basically didn't want to come in because upon investigation, there was an investigation that day of that incident. She recanted and said that she thinks that her breast may have been touched. In massage, we do pecs. when you have neck issues, you cannot loosen your neck and shoulders without doing pecs. She agreed to get the pecs done, and she said she thinks she may have gotten her nipples touched. You know,
Do you recall if Miss Gibbs testified outside the presence of the jury? In other words, said, hey, here's what my testimony is going to be? Or
she didn't understand.
Before the jury was in the courtroom, or just while the jury was there?
She actually testified in front of a jury.
Okay, well, that part I understand. So it does sound like there was a hearing. I'll look for it. My guess is it's going to be in volume 1 of the trial transcript. This would have been when they talked about it. I read the report that you read, which is why I was starting to get concerned. If a judge had not already ruled on this, we were going to need to have a conversation because of what you and your lawyer described in Massage Envy's internal investigation.
She reluctantly let it in. The judge did, but it was argued for quite a while, but she reluctantly let it in.
Okay. Well, I will look for that in the transcript, and we may revisit it tomorrow morning. I appreciate that Ms. Gibbs is under subpoena. She should remain under subpoena. But I'll want to see what the argument was. And then I also have the benefit that Judge Reeder didn't have of Ms. Gibbs's trial testimony. And that will inform how we work through this as well.
Yeah.
Okay.
And we did hear back from 88 Fox. He said it was ruled on right before the trial, but he does not know if an order was entered. Says it was one of those, we will hear it before jury selection.
Okay. And here we see what happens when that's how it plays out. Understood.
So, Judge, just to clarify, you're going to read the record today. Do we need to have a witness present for 4:13 tomorrow morning?
No. No, I'll read both the discussion that was had before trial as well as Ms. Gibbs's trial testimony. And then we'll talk about it, meaning the parties will talk about it tomorrow. It's not going to be a surprise that the state says we next call Ms. Gibbs, and I say, no, you don't. I'll let you know before we pick a jury whether I'm going to maintain the status quo or if at my discretion I'm revisiting it.
Your Honor, perhaps you have some special access that we don't, but I'm not seeing a transcript from that first trial of August.
Oh, huh. Well, that'll make it hard to look at, and that's interesting. It was so long ago.
It was September, the Labor Day, the Tuesday after Labor Day 2 years ago, September 2019.
I just
3-day trial.
It was in there. I don't have a specific, I don't have special access, by the way. There's not a judge's docket where it gives me report cards on Mr. Whitenauer. Oh, man.
The only transcript that I see, Judge, is going to be from the Beretta hearing.
That's mine, though. That just means, I guess, I have a good court reporter. Who knows? All right.
But for the record, Judge, she's the only witness that they have that I oppose.
Okay.
All the other witnesses I'm familiar with.
So I do not have a transcript. That's an interesting development. I'll look into that. All right. Mr. Whitenauer, anything else we need to talk about right now about State versus Tavares?
Yes, Judge, and I don't know if you want to take up today or tomorrow, but there would be some motion limits from the state with respect to what we understand to be Mr. Tavares' intent to call certain witnesses that we believe would be called for the sole purpose of character. And we would make a motion limiting to exclude those witnesses or their testimony as to his character or his really proper services in the past with respect to massage. We'd also make a motion limiting as to some other matters, including excluding any mention of the prior trial or any issues with prior counsel. But I don't know if you're wants to pick it up now or tomorrow.
I think we can do that tomorrow. Are these will be oral motions in limine?
Yes.
But are there more topics, or it would be, and Mr. Parrish flagged this, I think, last week, concerns about potential witnesses, and then references to prior trial and references to dissatisfaction with prior counsel.
Yes, and obviously, punishment also, but those will.
Okay, all right. Mr. Tavares, I need a witness list from you.
On here.
If you've got one, that would be great.
I did put one through the portal,
Oh,
but, you know.
oh, look at this. Hold on. Stop the press. You may have. It just shows up a little differently. Let me see through the portal.
But.
I've got 5 names.
Yeah.
Is that it?
These are witnesses, because I had a state registered mobile massage business for several years prior to this incident. And so the mobile massage business, I actually went in homes and did massages.
Okay.
So I had well over probably about 25, 30 female people that I massaged that would say that I went in their homes and there was never any illicit behavior. So that's, you could call them somewhat character witnesses, but I mean, at the last trial, they had the girl's mother up there. That's somewhat of a character witness as far as I'm concerned.
Okay. Well, so what I'm concerned with isn't so much your perspective or Mr. Whitenauer's as to whatnot, but the law's perspective on what constitutes proper and improper character information. And I will be reviewing what the evidence code says about that. I will tell you that as a general proposition, in the same way that generally the state is not allowed to come in here and say, hey, Mr. Tavares burgled this house on this day. It's not what he's charged with, but he burgled a place once before. That's why we know he did it this time, because that's what he does. He has a propensity to burgle places. That's generally not allowed. What the jury is working through is, did Robert McBurney burgle this house on this day? Well, the flip side of that is that I don't get to come in, if I'm the defendant, and say, well, look at all these other houses I went into and I was allowed in, I was invited in, I didn't take anything. And so it is likely the case, I'm not ruling now, because I want to give you a chance to articulate it a little bit more, but it is likely the case that you would not be allowed to call a witness whose sole purpose would be to say, hey, Mr. Tavares gave me a massage in my own house, nothing bad happened,
Okay.
and I trust him.
All right, understood.
There are ways that you can have character evidence admitted. You may want to look that up, but it rarely involves specific instances of good acts.
But I
It's
would
very generic. It's someone saying, hey, he's a good guy, basically.
But I would be able to mention that even without having witnesses.
So you will be given a chance to testify, should you choose to testify. When the state rests, then I'll ask you if you're going to put up any evidence. You could do that by calling witnesses, including yourself. You could choose to testify. It's a little different when you're pro se. It's more like giving a speech. Typically, the pro se litigant doesn't say, Mr. Tavares, what's your name? Gary Tavares. When were you born? You basically give a little speech. I'm Gary Tavares. I'm a massage therapist, or whatever the technical term is. I'm licensed, and I wasn't there the day this happened. And then you call an alibi witness, whatever your defense might be. So you'll have a chance to talk to the jury about certain things.
Okay.
But there are limits about what a defendant can get into in his own defense. So maybe there are objections raised about things. But if you were to say, for example, I've never done something like this before, the defendant can say that, then that opens doors for the state to say, well, what about this? What about this? What about this? There may be no what about this.
There is no what.
Okay, so we'll navigate that as we do it. But to your point, it's different if you're saying it as opposed to bringing someone in. I'm Crystal Braddock, and I had Mr. Tavares into my house when he was running Tavares Wellness LLC. There were no issues. It was all good. Massaged my back, left, and I was satisfied with the services he provided.
Okay, now, as far as the last trial, that is very important for this trial, because as you review the transcripts, you will see the stories that have changed from the witnesses from one case to from the initial statements to the trial. And I'm sure they may change this time. It's imperative that I am able to reflect back on what they said in that last trial. That's just justice, and that's fair. They clearly lied in the last trial. So I want to be able to say, okay, to cross them on what they said at the last trial. And that's fair.
It is fair. You run this risk because no one has asked for transcripts, and that was up to the parties to ask for transcripts. And I don't see them in the docket. Is that you may recall that witness John Doe said it was raining out that day. That's what he said at trial. And he comes in this week and says it was hot and sunny. And you say, wait a minute, John Doe, wasn't there another proceeding in this case? You're not going to get to talk about the fact that there was another trial. Not okay. That was, you heard Mr. Whitenauer, one of his motions that he wants to talk about tomorrow is he doesn't want people to refer to a previous trial. And that's a valid motion. And the case law is pretty clear that we don't talk about the fact that there was a trial before. But the way you get around that, because if someone came in under oath in connection with your charges and said it was raining, you said, hey, John Doe, have you ever testified in another proceeding? Don't use the T word. You don't say another trial. In another proceeding connected to these charges. You'll come up with your own words that you use, but have you ever testified before in connection with these charges? Well, yeah, I did. All right. And were you asked what the weather was like? Yeah. And what'd you say? I don't remember. Didn't you say it was raining? You are free to ask that question, but here's where we're in a little bit of a dilemma. If he says, nah, I said it was sunny out the other time I testified in connection with your charges, you don't have a transcript to say, look on page 75, you said it was raining. I don't have that either. No one has asked for the transcript.
But it is a court record. The transcript and the trial was a court record. So if they say that they didn't say it, then they are impeached because they did say it in the court under oath. The transcript is a court record.
If a transcript exists,
it is a transcript because it's been probably over a year or two ago. I tried to get the transcripts from the records book, and they have the transcript, but it was very expensive. So at that time, I didn't get it.
Okay,
they do have the transcript.
Let me look into that because I think everyone would like that.
They wanted I think $1,200 for it or something, and I wasn't at that time ready to do it. But there is a transcript of it because I don't need a transcript. I remember everything that happened. Okay. I remember every witness's testimony. I don't need no transcripts.
Okay. I'd like one. And so if they're out there, I'll get them. I don't know. They're not in the docket.
Yeah, I know there is one out there. There's definitely, because I tried to get it. But
so anyway, I just want to let you know, I do see your witness list. Excuse me, I've printed it out now. And if what these women were going to say is, when I got my massage, there was no problem, that's probably not going to be admissible, because that would be the same way as the state coming in, bringing in all these other people for which you're not charged, saying, oh, he creeped me out. I did not like how he touched me.
Okay, that's understood. That's understood. To be quite honest, I could do this with no witnesses. So
you're going to do it the way you do it. I just let you know that those 5, you may want to leave them on call. We'll see. Things are dynamic in a trial, but as it's forecast, I don't think that they would be testifying.
Okay. All right.
I think, I know what I need to do, which is look for a transcript, and I'll let both sides know if I get my hands on it. Otherwise, we will talk tomorrow morning about jury selection and the motions in limine, which sound pretty fundamental, nothing exotic. Anything else from the state? How long do you envision your presentation going? I asked Mr. Parrish that. He gave an estimate, but said he's not lead.
Judge, I would think that, say, on 5 witnesses, I think we could, be done with state's case in a day, perhaps it's still on to just 30 minutes or an hour the next morning. But I don't anticipate long.
So if I were to tell, and we'll repeat this tomorrow morning, but if I were to tell the jurors they ought to be done by Friday, unless, if their deliberations take 6 days, that's on them, but we'll get the case to them easily by Friday.
Yes.
Okay, you're comfortable with that?
Yes,
And your 5 witnesses includes Ms. Gibbs?
that is correct.
All right. Mr. DeVos, I asked this of you already, and I'm assuming your answer hasn't changed because you remain lead counsel, if you will, but your thought was that your presentation may be limited to you. It may include a couple of these folks, but you think that we ought to be able to get the case into the jurors' hands by Friday pretty easily?
I would say so. I can't deny that.
Okay. All right, I'm not holding you guys to it. It's just, it's helpful to them because one of the questions that I have to ask them is, who's got a conflict? And if their conflict is next Tuesday, that's not a conflict because we won't be here next Tuesday. They'll have the case and in theory, they'll be done. All right. Well, thank you. I need to see you guys here tomorrow at 9 and we will begin the trial. The trial starts when we, part of it starts when we start picking the jury. That'll be an all-day affair. We don't break for lunch other than as long as the court reporter needs a lunch break. On the regular trial days, you'll get an hour for lunch. But I'm just letting you know, we have 60 people stuck in a medium-sized space, and I want to keep them there as briefly as possible. So if you were thinking, where's my hour-long lunch break? Is probably not happening tomorrow. I have to let Ms. Rivers take a break, and I will, but that might not be a full-blown hour. So bring your supplies. If you were thinking, great, I'm going to go over to Broad Street and eat a leisurely lunch, maybe Wednesday, maybe Thursday, but not tomorrow.
Yes, Judge, just one question, would you be anticipating us opening tomorrow, or we'll start with that on Wednesday morning?
That'll be Wednesday. I was going to explain this tomorrow, but the potential jurors are excused after each panel is done, so they don't have to stay in the building. So when you all have asked the questions you're going to ask of the first 10 to 15, I tell them, go home. We have a phone number and email address, but when you are making your strikes, you are not going to have a room full of 60 people. So I will definitely not be requiring those who are selected to scream on down here at 4 o'clock on Tuesday. So Wednesday morning, we'll get our jurors in here. I'll give them some preliminary instructions and you'll give opening statements if you want to on Wednesday morning. Tomorrow is jury selection only. If we've got some bonus time after that's done, there may be a few issues that we paused on because the jurors were ready before we finished our discussions tomorrow morning. Okay. All right, Mr. Tavares, anything else?
I can't think of anything.
All right. Well, if you do, write it down and we'll talk about it tomorrow morning.
9 o'clock, okay.
9 o'clock right here. Thank you. You all are here for Hinton. He did not change his mind. All right, let's turn to Mr. Buford. Did he, just want to know if he came.
He's on his way, Your Honor. I reached him on the phone.
Okay, and did you talk with the prosecutor? Are you in a position to handle his plea?
I can handle his plea if it's what I think it is.
Okay.
The assistant DA was on the case.
You'll want to find Ms. Hall because it's her case. Yeah. And what we'll do now is turn to Mr. Johnson, your client, and we'll bring him out.
Judge, Mr. Tavares is not on the case, not being excused.
Yes, sir.
Thank you.
So we have Mr. Duncan. Do you need to talk to him for, well, you can talk at the table. You okay talking at the table?
Yes.
Great.
Yes, thank you, Judge.
No problem. As you saw, we had plenty of other things to do. Is Mr. Duncan pleading to what's charged? Is there a change in charges?
It's a reduction.
Okay,
We may need misdemeanor probation.
okay, that, it doesn't work quite like that anymore, but we'll figure that out.
Okay.
If maybe excuse me for that, I will return for one other matter on this calendar.
Sure.
Yeah, I mean, get back.
Are you handling, Sonny Miller?
Yes, sir.
Okay, great. Yeah, do come back.
Yes, sir.
All right, Mr. Johnson, are we ready?
Yes, Your Honor.
Ms. Patel?
Yes, thank you. Mr. Duncan, will you please raise your right hand?
Well, let me get a couple things on the record first, then we'll get going. All right, so this is position 10 on our trial calendar, State versus Mario Duncan, 19 SC 165967. Good morning, Mr. Duncan.
Morning.
Mr. Duncan, in a moment, Ms. Patel is going to put you under oath. Once you're under oath, it's important that you answer all of her questions truthfully and completely. So I need you to speak up a little, and we may want to move the microphone towards you a little bit because you just got to bend the stock. There we go. So that the court reporter can hear you. If you have any questions while we're going through this, Mr. Duncan, you need to let Mr. Johnson know. Will you do that?
Yes, sir.
Okay. When you're ready, Ms. Patel.
Thank you. Mr. Duncan, will you please raise your right hand? Do you swear or affirm that the testimony you shall give in matters currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. If you can put your hand down. Please state your true, correct, and legal name.
Mario Duncan.
And are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
And is there a medicine that you normally take that you haven't taken today?
Yes, I took it this morning.
Okay, so you understand this proceeding?
Yes, ma'am.
Okay, thank you. How old are you and how far have you gone in school?
I am 52 years old.
And how far have you gone in school?
12th grade.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your lawyer about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with his services?
Yes, ma'am.
Counsel, do you waive formal reading of the indictment?
Yes,
Do you waive any and all defects in the indictment, including with respect to the defendant's name?
yes,
Thank you. Mr. Duncan, were you arrested on these charges?
Yes, ma'am.
And the state is unaware of any outstanding warrants. Do you or your attorney know of any outstanding warrants?
No, ma'am.
I don't know.
Has your attorney advised you that the minimum and maximum sentence for the charge you're pleading to, and originally you were charged with enticing children for indecent purposes, however, it's being reduced to disorderly conduct. Are you aware that the minimum maximum is 1 day up to 12 months?
Yes, ma'am.
Do you understand that this is a negotiated plea of guilty, which means the state will recommend to the court a sentence of 11 months of probation to include any alcohol, drug evaluation, and for you to do any treatment that may be deemed necessary by that evaluation, and any sort of family violence or this family violence intervention program that is also involved with your probation, and to have no contact with the victim.
Yes, ma'am.
You understand that the court does not have to accept that recommendation and can sentence you the maximum on this charge instead.
Yes, ma'am.
Do you understand that this plea could be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that if you're not in the United States, sorry about that. Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or your ability to obtain employment.
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that if you went to trial, you'd have a right to trial by jury, the right to remain silent and not incriminate yourself, and the right to see, hear, and confront witnesses called to testify against you?
Yes, ma'am.
Do you understand that by pleading guilty, you give up the following rights: the right to trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond reasonable doubt, and the right to appeal if convicted of these charges after a trial?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, ma'am.
How do you plead to the charge of disorderly conduct in indictment number 19 SC 165967?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you have only 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Thank you, Mr. Duncan.
Thank you too, ma'am.
Your Honor, the defendant has no prior felony convictions or prior arrests. The state defense have agreed to a joint sentence recommendation of 11 months of misdemeanor probation, and for Mr. Duncan to complete any alcohol and drug evaluation, any treatment necessary, and a family violence prevention program. This case occurred at 4117 Stone Trace Drive, which is in East Point. On June 30th of 2017, the victim, Ms. Jasmine Stitt, was staying at the defendant's house, helping the defendant and his wife move some items into the garage. She had taken a few bags and gone into the garage and put the bags down. At that point, the defendant approached her. He attempted to kiss her on the mouth. She resisted, however, and the defendant then asked her to keep it a secret. The victim was able to get away and run to an upstairs bedroom. Later on that day, she disclosed to her mother. Her mother confronted the defendant's wife. An altercation happened, and I believe the defendant was then taken into custody after a few months, after there was a forensic interview and everything. The defendant did admit to being in the residence at that time and that he was drinking. However, the victim did let me know that he hadn't actually made any physical contact with his mouth. He had just put his hands on her hips. For the enticement charge, it does require exploitation, which we found that we couldn't prove in this case. So
Okay.
For that reason, we're reducing it to disorderly conduct.
How old was Ms. Stitt at the time?
15.
15. All right. So she's adult now and is okay with this resolution?
I had told her that this is a resolution we were moving forward with, and the reasoning, I don't think she was necessarily happy with it, but she understood my reasoning.
Okay, got it. And the connection between Ms. Stitt and defendant is simply she had been, I guess, hired or was volunteering to help them move?
No, sorry about that. The defendant's wife is Ms. Stitt's cousin.
Okay,
Yeah, but there is no contact between them anymore, so a no contact provision would be appropriate.
and Mr. Duncan has been in custody since he was arrested on these charges, or he was in, I've got a big old number next to his name in terms of days in jail.
I think it's a year. Is it more than that?
I have 568 days.
So it's 2017, Judge.
Okay, so he was arrested and he's been in since then. Okay. Time to get out, Mr. Duncan.
Yes, sir.
Thank you for that, Ms. Patel. Good morning, Ms. Crawford.
Good morning, Judge McBurney.
Do you have any Georgia criminal history for Mr. Duncan?
Mr. Duncan does not have any felony history.
Thank you. Mr. Duncan, where are you from? Where were you born?
No, sir, Bahamas.
Are you a U.S. citizen?
No, sir.
Okay. Do you understand that this guilty plea could have an impact on your immigration status?
Yes, sir.
Okay. And I know Mr. Johnson has worked very hard on your behalf since he assumed responsibility for the case, and he may well have shared with you his view on the likely impact of this plea on your immigration status. But you understand it's not Mr. Johnson's decision what happens.
Yes, sir.
That U.S. immigration authorities could look at this and say, I understand that it's disorderly, but we don't like the allegations, and it's time for Mr. Duncan to not be in the United States anymore. You understand that is a possible, maybe not likely, but a possible outcome.
Yes, sir.
Understanding that there could be an impact on your ability to remain in the United States. Do you want to go forward with your plea?
Yes, sir.
You mentioned that you take medication. What's the medication that you take?
Physical medication, not mental.
Okay, but what is it addressing? Like, is it blood pressure medication or?
I take blood pressure medication also.
And what else do you take?
I take Prescovix, Descovy, for HIV.
Okay. And does any of the medication that you take make it hard for you to understand things after you take it?
No, sir.
All right, so you feel like you followed what we were discussing?
Yes, sir.
Got it. Thank you so much. Mr. Johnson, what do you want to tell me about Mr. Duncan and his situation?
Well, I have nothing to say except for that we would ask the court to accept the recommendation of
Okay.
the prosecutor in the case. I also want to make some clarity on, I see a couple of other case numbers. I know we're talking about 19. I have a 17 DA 14094. I just want to make sure that we have.
That may be the district attorney's office's tracking number for these charges, but there are no open cases against Mr. Duncan that anyone is aware of besides.
Yeah, I just want to make sure that that was the only case number.
Okay. Got it. All right. Mr. Duncan, Ms. Patel mentioned that you're married. Does your wife live here in the Atlanta area?
Yes, sir.
And is that where you'll go live when you're released?
Yes, sir.
Okay. Does she know you may be coming home soon?
I talked on Saturday, but they have the phones in the jail. They have the phones, the accounts frozen, so I didn't make any call from Saturday.
Okay. All right.
Your Honor, does your record show that Mr. Duncan has a bond?
Well, it does say that there's a $10,000 bond through A Rapid Bonding Company.
Right.
But he's going to be, that bond won't play much of a role anymore. Just looking his case up. Okay. All right. Well, Mr. Duncan, anything you want to add?
No, sir.
I find there's a factual basis for your plea that in June of 2017, you engaged in conduct with Ms. Stitt that you should not have, and it was disorderly in nature. So I'll accept your plea to the reduced charge of disorderly conduct, which is a violation of OCGA 16-11-39. I also find that your plea is knowing and voluntary. Knowing means you've understood the things we talked about. Is that a fair statement?
Yes, sir.
Any questions about anything?
No, sir.
Voluntary means no one's forcing you to enter this plea. And after discussing it with Mr. Johnson and maybe your family, you've decided that this is the way you want to move forward. Is that true?
Yes, sir.
Then I'll accept your plea. I will follow the joint recommendation, which is that you serve 11 months on probation. It will be a special condition of your probation that you submit to a drug and alcohol abuse evaluation. And if that expert recommends any treatment, you go to classes or you take medication to curb your appetite for alcohol, you'll need to follow those recommendations. Do you understand that?
Yes, sir.
Ms. Patel, you asked that Mr. Duncan complete a family violence intervention program. I know what that is, and it is focused usually on the physical abuse of a family member. You struck your intimate partner, you shoved your intimate partner, etc. This doesn't quite fit in there. It doesn't mean it's inappropriate, but I'm curious about your thinking.
We had pulled previous 911 calls from that resident, and there was one family violence and domestic call out. So that's why I included that.
Okay, just something that may help Mr. Duncan navigate going forward. You'll also, Mr. Duncan, as a special condition of your probation, need to complete a family violence intervention program. And finally, you are to have no contact with Ms. Stitt, who is your wife's cousin. Don't call her, don't write her, don't try to go by wherever it is she lives. You understand that?
Yes, sir.
Mr. Duncan, were you working at the time this happened?
Yes, sir.
What kind of work do you do?
Handyman work.
Handyman work?
Yes, sir.
Is that something you'll be able to go back to, or medically will that be complicated?
No, it wouldn't be complicated, but I'm trying to move on with the immigration process so I could be more legal, where I could work with permit and stuff.
Got it.
I don't
Okay.
wanna work illegal.
Okay, so you're trying to get above the table rather than below the table.
Yes, sir.
Okay, well, I hope that works out for you. Just make sure you take care of your conditions of probation. Ms. Nelson, how does Mr. Duncan connect with misdemeanor probation? He's in custody now. He'll be released in the next day or two. What do we do?
If you can keep him, if the deputy can keep him up, I'll reach out to misdemeanor probation, see if someone can come to the courtroom.
Okay, will you let us know if the answer is no so that we can let Mr. Duncan get back?
Yes.
Okay, so Mr. Duncan, in the past, it was easy, and you may have heard Ms. Patel saying, hey, you need to get misdemeanor probation here. Someone will come from that, it's a private company, and they give you information about reporting. During the pandemic, they haven't been as available, and it's been something that you call in when you're out of custody. I don't know how that's going to work. It maybe there's someone in the building who can come by, and then that person will meet with you, give you some paperwork. It is important that you have that initial meeting with misdemeanor probation when you're released. That's how they establish contact with you. If they can't and you miss that meeting, then they typically bring a warrant to me saying, we don't know where Mr. Duncan is. He didn't show up for his meeting. Okay?
Yes, sir.
So don't miss that. Mr. Johnson, anything else for Mr. Duncan?
That's it, Your Honor.
All right. Thank you again for taking over this case. Ms. Patel, anything else? All right. So deputies, if you would keep Mr. Duncan up until we hear from Ms. Nelson, someone may meet with you, Mr. Duncan. If not, we'll get information to Mr. Johnson about where you need to go to have that meeting with probation when you get released.
Yes, sir.
All right. Thank you.
Thank
Thank you,
you.
Judge. Close my business, may I be excused, Your Honor?
Yes, sir.
Thank you.
All right. I think we can turn now to our 10 o'clock calendar. And our first case on that calendar is Mr. Miller. Let's see. Yeah, do we have Mr. Miller also?
I provided him the sign on. He should be on.
Is he iPhone? Is that Mr. Miller? Yep.
That's him.
Okay, great. Ms. Winfrey, good morning. I saw you on the call. I don't know that we've got a case. Are you handling this case or are you just spectating today?
Good morning, Judge. No, I saw that we had Michael Finley on for today at 10 for inquiry.
All right. Ms. Nelson, you know anything about that?
No, I don't see that. Maybe it was moved off of this calendar. I'll instant message you, Ms. Winfrey, and see if I can get the case number.
Okay, yes, so I looked in Odyssey and it's the day at 10 a.m. and if it's not, that's fine, just let me know.
What's the case number?
So the case number is 21 SC 177645.
There it is. All right, I will let I remember this case. So I'll let Ms. Nelson talk to you through the chat line. I don't know if it doesn't look like Ms. Rockwell ever filed an entry. So this is the guy who keeps coming to court and doesn't have a lawyer and keeps promising us he'll get one.
That's correct, Judge.
Okay, it is time to move it forward. All right, well, I'll let Ms. Nelson communicate with you through the chat line. And then I think we're just going to need to make him come into court and we'll get him a lawyer because he doesn't seem to be able to retain one.
Okay.
Thanks.
Thank you.
All right. So, Mr. Whitenauer, you're handling the Miller matter?
Yes, sir.
Great. Mr. Rosenblum, when you're ready, why don't you tell us what you hope to have done today?
Your Honor, this is a 2009 case. Mr. Miller was represented by counsel at that time. The prior counsel or someone, we can't really tell who, filed a change of address with the court. However, they left off the zip code. And
well, even more so, they just put a question mark.
Exactly.
Blank there. I don't know.
So I am certain that the post office, both here and also in New York, decided this wasn't necessary to send out. I don't know why it wasn't sent back to the court when any notices were resolved, but that was, again, 11 years ago. Mr. Miller has been arrested in New York, and that's when he found out that this warrant was actually still active. He did some time in New York. He's represented by counsel there. We've gotten him out of jail in New York on the promise that we would try to get this resolved here and get his bond reinstated and get the case back on calendar. So that's what we're asking for today. I have filed a change of address, including a zip code, and that was done back on August 2nd.
So the address in the system now is 121 Sunrise Lane in Levittown. Is that the correct address?
That is correct, Your Honor.
Okay, so we're good with the system.
Mm-hmm.
What was Mr. Miller arrested for in New York?
Mr. Miller, were you pulled over for a traffic violation and that's when they executed the warrant?
Yes, I was just pulled over.
For what? I mean, people don't get randomly pulled over. Why were you pulled over?
I had a crack in the passenger window, Your Honor, and that's why I was told that I was pulled over.
And then when you gave the officer your information and he or she ran it, they said, hey, by the way, you've got a warrant in Georgia?
Yeah.
Is that why you went into custody or were there other reasons why you went into custody?
Oh, that was the reason I went into custody, is because they said I have a warrant out of.
Okay.
So at this time, Your Honor, we're just asking that
Judge,
that the court reinstate
James
the
D'Angelo.
case
I
and get him back on
represent
calendar.
Mr. Miller here in Nassau County, Long Island.
Yeah, can you say your name again?
My name is James D'Angelo. I'm an attorney in Long Island, New York, and I represent Mr. Miller here in Nassau County. And what he said is accurate. The police officer didn't write any summons. The only charge he was taken into custody for was this Georgia matter. A bail was set, and we have to go back next Tuesday afternoon to see a Nassau County Court judge and advise him of the status of this Georgia warrant.
Got it. Okay. Mr. Rosenblum, thank you for that update. Mr. Rosenblum, I don't see a bond. Maybe it was set when it was a complaint, but I'm looking at the docket. It's admittedly old, and the records from like 2012 are a little spotty. But I couldn't tell you what the original bond was in this case. So I don't know if Mr. Weidenauer, because he might have a paper file, has something more. I don't know if this was a direct indictment so that your client was never arrested, so it would be setting a bond. It's hard to know.
That's my dilemma as well, Your Honor, based on what I was able to find.
Okay. And I guess what we could do is order up the paper file. I'd be more inclined to set a new bond, because by the time we got the paper file, Mr. Miller we would not get it before he has to get back in front of this judge in Nassau County, and that judge may be unhappy with him because he didn't have a bond. Let me hear from Mr. Weidenauer if he is comfortable having a bond set or if he opposes that. And then I'll hear from you, Mr. Rosenblum.
Thank you, Judge. I have reviewed the case, and I have only seen this incident as being the defendant's only incident in Georgia. He does have some history out of New York, this 2006 DUI offense. I would ask that Your Honor set a new bond, because I too am unable to see any bond in the docket. So I would ask that Your Honor set a reasonable bond.
Okay. Mr. Rosenblum, I cannot legally, as you probably know, as a Georgia lawyer, set a signature bond for Mr. Miller. I don't know that that's appropriate anyway, but the charges that he faces are serious. And because they are serious, they fall on that list of charges for which a unsecured judicial release bond is statutorily prohibited. So we need to set a bond that has some dollar amount that Mr. Miller will need to make. I'm open to hearing from you as to what that would be.
Your Honor, given the state's statement, the last thing Mr. Miller has is a 2006 DUI, which is a misdemeanor, and no further criminal activity before or after this event up and through 2021, other than apparently a cracked windshield. We would ask for the court to set as low a bond as possible, and also take into consideration that Mr. Miller is a resident of New York, so he will have to come down here to set said bond and be processed through the Fulton County Jail if necessary. So as light a bond as possible to accommodate.
Okay.
Represented by counsel back in 2010 or 11, and he, was under their services, under the assumption that this was being resolved, and as such, this was not an intentional avoidance of the court system.
Mr. Miller, are you employed?
Yes, Your Honor.
What do you do?
Your Honor, I buy, sell, and trade classic cars. I also play a little bit on the stock market.
What's a classic car?
Classic automobiles.
Right. What, like a VW Beetle or a Mustang? What is or like a Model T? What's a classic car?
Classic car is anything or vintage. Anything 25 years old or older is considered a classic. I buy and sell a little bit of everything.
Okay. And is there a storefront that you have, or is this virtual, you run it out of your house?
No, I do it privately. It's also, like I said, a buy, sell, and trade type thing. It's a hobby that makes a good amount of money.
What is your connection to Georgia?
I have no connection, Your Honor.
Okay. At some point, it sounds like you were in Georgia. Were you just visiting at the time, or what? I'm just trying to understand why you, someone who is on Long Island or wherever you are, was down in Georgia. Just visiting?
No, Your Honor. I was never there, Your Honor.
You've never been to Georgia?
No, Your Honor.
Other than his 2006 incident, have you been in Georgia?
What is my 2006
DUI?
incident? That was here in New York.
That was in New York.
Okay, well, this can be an interesting case, however it works out. But I will set a $10,000 bond at $2,500 per count. Mr. Miller can make that through a bonding agency, however he wants to make it. The only condition that I can think of that I think makes sense at this point is that Mr. Miller have no contact with Nicholas Demetro, Demetro. That's the individual who is the alleged victim in this case. And there's some court order that was in place requiring Mr. Miller not to have contact with Mr. Demetro. That's why there's an aggravated stalking charge. So again, I don't know Mr. Miller's connection to Georgia. I'm a little bit at a loss. He says he's never been here. But the way the indictment reads, it would be hard for him to have allegedly committed some of the offenses without being here in Georgia. We don't need to work through that today, but I'll set that bond. I'm not interested in Mr. Miller at this point needing to go back into custody. Hopefully Mr. Rosenblum and Mr. Miller's New York counsel can work with Mr. Weidenauer, and we'll figure out what should happen with this case from 11 or 12 years ago.
Yes, Judge.
So Judge, just for clarification, as far as the warrant is concerned, will that be withdrawn today?
Yes, because I'm signing a bond order today. But the tricky part is, I guess what I'll do is include as a condition, you should find out, Mr. Rosenblum, how much time Mr. Miller needs to make that bond. Because there'll be this window of unknown length where there's no warrant for someone who didn't show up for court, and there's no bond until Mr. Miller actually posts that bond. And if this were a normal case, he'd be sitting in jail, and the easy thing would be once he's posted the bond, he's out and we're all set. So that's the only question I've got is how long you think it will take for Mr. Miller to post this bond.
Well, Your Honor, I believe he's going to go through a bonding agency here in Georgia. So it would be, 10 to 15% of whatever that is. So Mr. Miller, that would be about $1,500 to $2,000. Would you be able to make that bond in the next day or so?
Yeah.
Okay. So I will put Mr. Miller in touch with a bonding company that I know of who can work with him and see what their procedure is to go ahead and place the bond.
Fair enough. I will, what I'll do is lift the warrant or cancel the warrant, whatever the right verb is. But then I'll have Ms. Nelson, my litigation manager, check this case file. And if by the end of the week, so this Friday, there's no bond in place, for Mr. Miller, then I'll reinstate the warrant. We will reach out to you first, Mr. Rosenblum, to say why are things not done yet? And if there's a good reason, we'll hold off. But if there's not a good reason, it's just Mr. Miller didn't get around to it, then I'll reinstate the warrant and it will remain in place until I see that the bond has been met.
Thank you, Your Honor.
All right, Mr. Weidenauer, anything else from the state in Mr. Miller's case?
No, Judge, I'll reach out to Mr. Rosenblum to see if we can find out if his client was order.
Okay, yeah, I suggest you guys work through that. And Mr. Rosenblum, I assume you have no discovery in this case.
All I have is what I've provided the state reciprocal discovery, but no, I have not received any discovery on this case yet.
All right, well, you and Mr. Weidenauer can get working on this to figure out what's going on. This will be a higher priority case for me just because of its age. We'll want to try to get closure on it sooner rather than later.
Understood, Your Honor.
All right, Mr. Miller, do you have any questions for me, or are you going to work through your lawyers?
No, Your Honor, I will ask my attorneys any questions.
Sounds like a plan. Thank you, everyone.
Thank you, Your Honor.
If that concludes my business, may I be?
Yes, sir.
Thank you, Judge.
Excuse as well.
Yes, ma'am. Thank you.
Yeah, seems like well.
Mr. Webb,
Your Honor.
do we have Dante Buford?
He is on his way, Your Honor. I spoke to him by telephone somewhere in the neighborhood of 9:30. And he told me that I think he said he was in the road, but he would be here, he said shortly after 10.
Okay, why don't you check with him again? Because it's now a little after 10. And I just want to know if he's showing up or if we need to encourage him to be here.
Yes, sir. I'll go call right now.
Thanks. Ms. Hall, you and Mr. Webb have discussed this, and as far as you're concerned, it's ready to go. We just need Mr. Buford.
That's right.
Great, okay. So misdemeanor probation is on its way. I need to just finish this Mr. Duncan's sentence, and they will meet with him. Oh, there they are. Hey, let me get you the sentence. Just a sec. Is it easier for you if we bring Mr. Duncan out here?
Yes.
Okay, we can do that because we're on a little bit of a break.
They're gonna bring them. Okay, I'm making the job hard.
Hey, Mr. Duncan, the folks from misdemeanor probation are here. I'm just printing out your sentence and they're going to chat with you about your next steps, okay?
Yes, sir.
All right, if you could put your mask over your nose, that would be great.
Your Honor.
Yes, sir.
Mr. Buford is down, he said he was right down by the courthouse park.
Excellent.
Yeah.
We'll sit tight.
Okay. Yeah, I'm always in favor. It's just I'm trying to get.
So I don't have the stapler's right here if you want to staple it, but this is the sentence. Thank you. So if you do a trial and it's a mistrial, do you not make a transcript unless someone says, please make a? Interesting.
And I think he tried to believe it.
Right, because he was told, hey, it's $1,200. Yeah. It's not, Deidre reached out. It sounds like it was Sherry's case. And she said, hey, it's a mistrial. And I get it. I'm surprised that the state. Yeah, they should have, but it sounds like because of a transition in personnel, the guy who tried it's like, I'm gone. He wasn't thinking to ask for it. And so gonna make for a slightly messier trial.
411 7 that's what I was
Yeah.
in, but my wife moved. I'll have to call her to find out exactly where it is. It's Vesta Avenue. I don't know the complete address. We was at 4117 Stone Trace Drive. 7 Stone Trace Drive. That's right. 30244. 404 957 3671 71. My number is 404 617 1699. That's my wife's number, the fourth, yes, ma'am. Mario. That's one.
She might have,
Duncan.
she's on right now. Ms. Nelson?
Annie.
Yes, Judge?
Hey, misdemeanor probation is here with the question of whether during sort of peak COVID, when we would have been doing most things remotely, if you ever emailed to misdemeanor probation any referrals that so-and-so has been referred to misdemeanor probation.
Usually if we taken a sentence, I would email them a copy of the sentence, not necessarily the referral. Well, I've done that a couple of times too. Now that I think of it, I have.
Was she emailing to Thomas, to Steve Thomas?
Were you emailing to, here, you can talk.
I'm sorry. Thank you. Yes, ma'am. Were you emailing it to a Thomas? I think it was
Miss Allen, I know I emailed.
Miss Allen. Okay.
Mhm.
Okay, great. That's good. Because I was just going to say Miss Thomas is no longer with our company. So I just want to make sure we're receiving all of your paperwork.
Okay, yeah, usually I copy Miss Allen on it.
Okay, great. Thank you.
No problem.
Okay.
No. Hopefully. Oh, yeah, that was immigration.
We do have immigration.
Yeah.
In this field, scheduled for 2 weeks. Yeah, the sugar,
Pardon? Don't matter.
So, we're sending your first appointment to South September 14th. That in, you have a federal 49 information.
But I got
They'll figure it out once you report. You're being probated for these on the temple. You have to submit, temporary evaluation, 49 hours. Storage fees, health records, like wages, and yeah, we would really allow this interest.
Family violence. I know family violence. I don't know where they get that from.
They'll, well.
Thank you. Yes, ma'am. Thank you.
Mr. Duncan, did you get what you need?
Yes, sir.
All right. Thank you.
Thank you, too.
You too.
Jan, question?
Yeah.
Are we bringing Hinton out for any reason?
We are not. Hinton was here in case he had a change of heart over the weekend. His heart did not change, so he's good to go.
Okay. I'll let him know.
He's supposed to move from trial.
So he was on the calendar today, but you got to, okay, maybe it was Thursday when you may have been on your special project. Yeah, it may have been Thursday. State asked for a little more time, defense asked for more time, and Hinton was here and I got him to say on the record, I am okay with more time. His family wants to hire a different lawyer. So, we are deferring it to the next trial calendar.
All right. I didn't- you want me to put some judge, and I know how the security works. Yeah. Cooking schedule 3, right? I forgot. Okay. What? Which one? Oh, is it one? If it's one, then the minimum, I think, is 5, right?
The minimum for possession is only 1 to 3.
Oh, you're reducing it to possession, okay.
No, that's count 2, so count 1 is WID, that's 1 to 3rd.
Oh,
So he has 2 counts of possessions on that, on this impact. One is possession of WID and one's just possession.
I wonder if my code is out of date. This is the 2019-2020 edition. Did they lower
I
that?
think that's the one.
Is it? It says schedule 1, 1, 2, it's 5 to 30. But then schedule 3, 45 is 1 to 10.
Yeah, I don't think it's good.
Look and try.
Oh, it's 2.
It's 2.
And possession is still 1 to 3. I would think 2 is 1 to 3.
Oh, so it'll have to be 5 probation then instead of 3. I told them 3.
No, it's 3. I'm still in the 3.
Oh.
But he has to be suspended for the possession during.
Oh, okay.
So then, I mean, that would be suspended, but it's gonna be 3.
Oh, okay.
Hey, how you doing? Hey, Ms. Young,
I'm Michael.
how are you?
I'm well, how are you?
Fine. They may have just taken Mr. Hinton downstairs. I don't know. I told them they could. Is he still up? Great. People who were here in connection with that case, I already said could go because Ms. Hall hadn't heard anything from Ms. Convery or Mr. Abate. You're free to talk to him, but it will be news to the world if it's, hey, I want to work the case out now.
I would be surprised, Judge. I've been communicating with his mother all weekend.
Okay.
And I got delayed, I apologize.
Not a problem. He's back there.
Thank you.
We'll get started in 1 second.
Yeah, sure.
Sure.
Thank you, Honor. Nothing's changed.
Okay.
Thank you. May I be excused?
Yes, but did you get any insight from your client's mother whether you'll be staying on the case? And if not, how soon someone else would get involved with the case?
I have not. I spoke with
his father and the other family for about an hour after court the other day.
Mhm.
And they were talking about somebody assisting instead of replacing.
Okay,
And I
well,
said,
great.
I'm fine with either. It's really about the client. It's not
Sure.
about my ego.
No.
I'll reach
But
out.
it certainly will make it flow more smoothly if you stay on the case.
And I'm not looking to get off.
Yeah.
I think it was all the discussions that prompted. So to my knowledge, I'm not being asked to be removed and.
Okay, you may be augmented.
Which is always a pleasure.
Yeah, all right, well, good.
Judge.
Thank you.
Do I get my money back today? Cause I bonded out in the short. I might have to go down to the sheriff's. Or not to this, it's a desk down.
Yes, ma'am.
It just occurred to me, I have not received an order yet. Or have the next court date, or should I just check this?
I haven't done the order yet, so you aren't in the dark about it. No one's received it yet. Sure. Okay. We now have Mr. Buford here. Good morning, Mr. Buford.
Morning, sir. I apologize, man, a little late.
It's okay. We're ready to go. This is position 2 on our 10 o'clock calendar. It's 17 SC 153369. We've got Ms. Hall representing the state, Mr. Webb representing Mr. Buford. Mr. Buford, my understanding is that you are prepared to enter a negotiated plea to this case. Is that correct?
Yes, sir.
In a moment, Ms. Hall will put you under oath. Once you're under oath, it's important you answer all her questions truthfully and completely.
Okay.
I may have a few questions as well. She'd answer those truthfully too. It is just as important that if you have your own questions, because you're hearing something that's not making sense, or it's not what you and Mr. Webb or Ms. Snyder, or you've had a few lawyers, have been talking about, you let Mr. Webb know, and if the two of you need to speak, we'll pause so that you are comfortable, that you follow what's going on. Does that make sense?
Yes, sir.
When you're ready, Ms. Hall.
Your Honor, you don't want us at the podium?
It's really up to you. As long as Ms. Rivers can hear you, you're welcome to be standing at the podium. If you're more comfortable sitting at council table, that works for me too.
Fine, I just meant, I didn't want to be disrespectful if you wanted me at the.
Not a problem. Thank you for asking.
Mr. Buford, can you please raise your right hand?
Yeah, ma'am.
Do you swear or affirm the testimony you should give in the matter currently before this court should be the truth, the whole truth, and nothing but the truth?
Yeah, ma'am.
Thank you. You may lower your hand. Please state your true, correct, and legal name.
That's Dante Buford.
And are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you normally take that you have not been given today?
No, ma'am.
How old are you and how far have you gone in school?
I believe I'm 37 and I graduated high school.
You think you're 37?
I'm 38. It's 1984. I forgot. Man.
Okay.
It's been a while.
You're probably 37 if you were born in 84.
And are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you've been charged with the following offenses? Possession of cocaine with intent to distribute, possession of cocaine, count 2, possession of firearm during the commission of a felony, possession of a controlled substance within a drug-free commercial zone, possession of marijuana less than 1 ounce, and possession of a firearm by a convicted felon.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to those charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney, Mr. Webb, about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with his services?
Yes, I am.
Counsel, do you waive formal reading of the indictment?
We do.
Do you waive any and all defects in the indictment, including with respect to the defendant's name?
We do.
And do you waive moving forward on a copy of the indictment?
We do.
Mr. Buford, have you been arrested on these charges?
Yes.
I ask because the state is unaware of any outstanding warrants that are related to these charges. Do you or your attorney know of any outstanding warrants related to these charges?
No.
No.
Has your attorney advised you of the minimum and maximum sentence to each charge that you're pleading to?
Yes, ma'am.
I remind you, possession of cocaine with intent to distribute is 1 to 30 years to serve. Possession, just simple possession of cocaine is 1 to 3 years to serve. Possession of firearm during the commission of a felony is 5 years to run consecutive to any other count. Possession of a controlled substance within a drug-free commercial zone is 1 to 20 years to serve. Possession of marijuana less than 1 ounce is 12 months to serve, and possession of a firearm by a convicted felon is 1 to 5 years to serve. You understand?
Yes, ma'am.
You understand this is a negotiated plea of guilty, which means the state will recommend to the court a sentence of 3 years, well, for count 1, possession of cocaine with intent to distribute, 3 years on probation to serve 75 days, credit for time served, balance on probation. All other felonies will run concurrent to that, except for count 3, which is possession of a firearm during the commission of a felony. That count will be 5 years suspended to run consecutive to count 1. And then 12 months probation for the possession of marijuana less than 1 ounce. Do you understand that the court does not have to accept that recommendation? The court can sentence you to the maximum on each of these charges and can run those sentences consecutively or one after another.
Yes, ma'am.
Do you understand this plea may be used to enhance other convictions in this jurisdiction as well as other jurisdictions, including the federal courts?
Yes, ma'am.
Do you understand if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes, ma'am.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Do you understand if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just as a conviction at trial would? And this is true regardless of any advice by your attorney or anyone else.
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that if you went to trial, you will have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Could you repeat that, ma'am?
Is it your decision to waive all the rights that you'll be giving up by taking this plea and enter a plea of guilty today?
Yes, ma'am.
How do you plead on indictment 17 SC 153369 to the charges of possession of cocaine with intent to distribute, simple possession of cocaine, possession of a firearm during the commission of a felony, possession of a controlled substance within a drug-free commercial zone, possession of marijuana less than 1 ounce, and possession of a firearm by a convicted felon?
Plead guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, it is.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you only have 30 days from today to appeal this guilty plea conviction?
Yes, ma'am.
And do you understand that you only have 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea.
Yes, ma'am.
Thank you. Your Honor, the state is aware of 3 prior convictions by the defendant. The most recent being a 2017 disposition. That was a possession of cocaine case, along with Your Honor, there are a total of 5 felony convictions. 2 17, 1 from Fulton County, 1 from Anderson County. And then there are 3 2009 cases which involve theft by taking and drugs of cocaine with intent to distribute. And had this case proceeded to trial, the state would have proven that on May the 24th, 2017 at 4874 Old National Highway, that's in College Park, Fulton County, Georgia. Officers were at that location, which is a hotel. They went to that location to execute a search warrant. The specific individuals was for Mr. Buford. When they got to that hotel, they asked for someone working there to have Mr. Buford come out to the lobby. Once they got him out to the lobby, they did execute the search warrant on the room with a knock and announce. There was another male there who opened the door. Upon searching that room, they did find different quantities of cocaine. I believe that the total amount being over 13 grams, but in different variations of hard rock and powder. I'm sorry, Your Honor. And Mr. Buford also was inside of that commercial zone. They did also find a firearm inside that hotel room as well. Mr. Buford was arrested and charged accordingly on scene. That is all from the state, Your Honor.
Thank you.
You're welcome.
Ms. Crawford, I have the repeat offender list in front of me, and it shows 4 Georgia convictions and then 1 from Anderson. I don't know if that's South Carolina or if there's an Anderson County in Georgia. But either way, my question for you is, did you have more convictions than that? And are there any that are open and active?
No, Judge, I showed 3 convictions, nothing open and active.
Thank you. All right. Mr. Webb.
Your Honor, I believe this is an appropriate resolution of the case, and I would ask you to accept the negotiated plea.
Ms. Hall, the 75 days comes from math that you did in connection with, it looks like Mr. Buford may have been in and out a couple times, maybe a bond forfeiture, and then he got his bond back, but your math is that it was around 75 days?
Yes, Your Honor, my math is, and I can give you the dates.
I don't need the specific,
Okay.
Ms. Nelson may want them, but
Okay.
that's
math,
where that number came from.
Yes, it came up to 80. I went down 5 just to be safe.
Okay. Mr. Buford, where'd you go to high school?
Towers High School.
Where's that?
In Decatur.
Okay. Do you live in Atlanta now or in DeKalb? Or none of the above?
I stay in Decatur.
Okay. Are you working?
I got it. I have been working like temp service work, but I actually got an interview at 2:00 somewhere in this area, just for a driving company or something.
Okay. A driving company, meaning what?
No, I think I'm gonna be driving like a van or something, delivering food or something.
Okay. How'd you get this job lead?
How did I get it?
Yeah.
Through Indeed.
Okay. Do you have a driver's license?
Definitely.
Definitely. What kind of work were you doing before this opportunity?
I was driving. I was at Walmart warehouse probably like 2 months ago. I had an emergency out of town or whatnot.
What was that?
This is my sister. I got ill.
Is she okay?
Yeah, she's fine.
All right. Do you have kids?
I have 1 son.
Here in Atlanta or in Decatur?
Yeah, in Atlanta.
How old is he?
He's 2.
2?
Yes, sir.
Little guy.
Yeah.
Is he with his mom?
Yes, sir.
What's his name?
Noah.
Noah. All right. Well, Mr. Buford, it sounds like things have changed a little bit for you from 2017, where you ran into a couple issues. This is one of those cases. It's an old case, but we do need to sort it out. I hope that you continue driving or whatever other opportunities you find yourself. Noah will be a whole lot better off with you in his life than him having to look at you through dirty glass because you're locked up. But those are hard decisions to make, and I hope you're able to make them the right way. Do you have anything you want to add to what you heard from Ms. Hall and from Mr. Webb?
No, sir.
Okay. Well, I find there's a factual basis for your plea. I also find that your plea is knowing and voluntary. A voluntary plea means this is what you want to do. You may not be thrilled that you're taking another guilty plea, but you've talked with your lawyer and you think this is the best way forward for you. Is that correct?
Yes, sir.
And a knowing plea just means you've understood everything. Do you have questions about anything?
No, not at all.
Not at all. I'll accept your plea. I'm sentencing you pursuant to the Probation Options Management Act. And all that means, Mr. Buford, is that if while you're on probation, you have a technical violation, you miss a meeting, you test positive for something just a few times, you and probation will work that out. You don't have to get in front of me. If you catch new charges, that type of violation, that comes back to me.
Yes, sir.
I will sentence you on counts 1, 2, 4, and 6 to 3 years to serve 2 months with a balance on probation. All those counts will run concurrently with each other. Your sentence on count 3 has to run consecutive, and it has to be 5 years. I will suspend those 5 years. So you'll still be under sentence. You won't be on probation. But if we just fast forward 4 years from now, you do your 3 years probation, that 4th, 5th, 6th year, you're on a suspended sentence. No one's looking over your shoulder. But 4 years from now, if you were to catch new charges, the state could seek to revoke your suspended sentence, to reinstate it, basically. So I don't want you to think that it's a free pass. It is if you stay out of trouble. But if 4 years from now you get caught with more drugs and a gun, not only would you have those new charges, but the state could say, hey, you know, you had that suspended sentence. We want you to reinstate it, Judge. And if I felt that was appropriate, I could. But it's totally unsupervised. There's no one watching you. It's not probation. You understand the difference?
Yes, sir.
Okay. And finally, count 5 is 12 months probation. But you know what? I'll make that easier. Count 5 is 2 months to serve. It will run concurrently with count 1. And you get credit for all the time you've been in. And it sounds like you've been in for about 80 days, which is 20 days more than 2 months. So you're not going back into custody unless you mess up on probation. Do you have the name of the hotel where Mr. Buford was arrested and his room was searched?
I do.
Your Honor, was it count 3 that was consecutive suspended or?
Correct, count 3.
Okay, I just want to make sure I know that.
So that we're clear, the total sentence is actually 8 years to serve 2 months, but only 3 of those 8 are years when Mr. Buford will be on probation. And you may have experienced this before, Mr. Buford. If you're doing fine on probation, pretty quickly they'll make that non-supervising, and they may choose to close it out early if they want. That's something you and probation can talk about after you've been on probation for a little bit.
So, Your Honor, it is Howard Johnson by Wyndham, Atlanta. However,
I bet it's not that anymore. Okay. I was just going to have Mr. Buford stay away from that hotel. I don't. Sure. What's the address?
the address is 4874 Old National Highway. That's in College Park.
Great.
30349.
All right. Mr. Buford, the special condition of your probation is to stay away from the business at 4874 Old National Highway in College Park, 30349. It's probably not the same name as it was when you were there, but there's probably still something there, and whatever it is, stay away. Should be easy. You live in Decatur, you're going to be delivering food, just don't deliver any food to that address.
Yes, sir.
All right, Ms. Hall, anything else in Mr. Buford's case?
Nothing further from the state, Your Honor.
Mr. Webb?
Nothing further from the defense, Your Honor.
Mr. Buford, in normal times, we pass around a lot of paper and people sign things. And one of the things you'd sign is your indictment indicating that you're entering a guilty plea. Do you authorize me to electronically sign the indictment for you, Mr. Buford?
Yes, sir.
Mr. Webb, can I sign for you?
You may, Your Honor.
And Ms. Hall?
Yes, sir.
All right. Last thing, we have probation on the phone. They're going to want to, well, on this call, you can look on your screen there. Ms. Crawford's going to be on the screen. She's going to confirm your address, get some contact information, and give you a reporting date. Hopefully, Mr. Webb can write that down for you so that you leave here with a piece of paper with that information on it, okay?
Yes, sir.
When you're ready, Ms. Crawford.
Good morning, Mr. Buford. I'm Ms. Crawford from Probation. I need to get a telephone number and an address from you.
470-624-7290. And the address. You ready?
Yes.
And the address is 2700 Kenridge Parkway, Decatur, Georgia, 30032.
Kenridge?
KENRIDGE.
Is there an apartment number?
Yeah, it's 2700.
Okay, so it's just 2700 Kenwood. Okay. And do you have an emergency contact name and telephone number?
Stardina White, and that's WYCHE at the end.
What's the first name?
Stardina. STARDINA.
And what's her telephone number?
404-615-3000.
Okay, I'm gonna give you reporting instructions. The date will be September 14th.
Okay.
September 14th at 9 a.m. The address will be 2910 Miller Road, Suite 150. That's in Decatur, Georgia.
Do I have to report it to Decatur? I can't, is it a way I can't report to Fulton?
If you live in County X, you are supervised by County X. So if you live in DeKalb, you're supervised by DeKalb. If you live in Gwinnett, you're supervised by Gwinnett. Why do you not like it there?
That's cool.
Okay. I'm just curious why you a big fan of Fulton probation?
No, it really don't matter.
Okay.
It don't matter.
Just so you know, we're not picking on you. That's how it works.
Right.
That's correct. Did you get the reporting date and time?
I have the date and time. What was the address on that again, please?
It's 2910-2910 Miller Road, MILLER Road, Suite
Okay.
150.
Suite one?
Suite 150, 150.
Okay.
That's Decatur, Georgia, 30035.
Okay, thank you.
You're welcome. You have any questions for me?
No.
Okay, thank you.
All right, I think that is it. So, Mr. Buford, don't miss that first date. That's when you make that connection. And if you're not there, they typically reach out to me to say, should we do a warrant? And I know you don't want that. So show up there and good luck with your interview this afternoon.
All right, thank you.
Mr. Webb, anything else?
No, Your Honor, may I be excused? I think this is my only case.
We, of course, had lots of cases on that calendar, but it's the only one you need to worry about today.
Well,
You are free to go. Ms. Hall, anything else? Mr. Abate, there were people here, that probation officer and a few others who are always interested in Hinton. Ms. Young showed up a little while ago. Mr. Hinton had no change of heart. So I didn't bring him out. Ms. Young told me that she thinks she'll stay on the case, but that she may get a partner, that the family may be hiring someone to assist rather than replace, which is a much better plan. No, nope, you don't need to be here tomorrow. We're going forward with Mr. Tavares, pro se. You bet. You too. So that is it, gentlemen. Thanks for your help. I'll have a 1:30. Oh, sorry about that. Yeah, there's that 1:30. Just in case someone wants to bring Mr. Hinton out at 1:30. We'll try to schedule more appropriately going forward. You know what? You should enjoy whatever it is, because assuming you get assigned to this trial, you're going to be, get your hands full until the end of the week. Have you done a jury trial yet?
I did the first one with Jones and
But like, were you the guy in charge of the jury? Because I assume you'll be in charge of our jury.
yeah, I was.
Because they're going to live over in 8H.
I did more civil than jury.
Oh, well, same thing. And here with the defendant on bond, it's only going to get complicated at verdict time. So, yeah, it'll be real interesting. But in the meantime, the jurors will be doing their thing over in 8H. So you'll get your steps in each day, because when we take a break, yeah, that's the space we got for them.
Oh, yeah.
Yeah.
So you won't have anything.
So no, these courtrooms are not available.
Ms. Nelson checked and she got us 8H. We'll minimize the breaks, but it just means like at lunchtime, that's where they'll retreat. Yeah. Yeah, that's what I said. Thanks, Ms. Rivers. I'll see you well before 9 tomorrow. Great.
Okay, I think I've got everything, Judge, that you needed. If you need anything else, holler at me.
Okay, I'm doing the signatures on the Buford indictment, and then I will send that to you. And I'll respond to your questions about this Miller guy.
Oh, okay. Yeah, I was a little confused as to what you were